Judgment in the matter of Perry versus Raleys Solicitors.
Lord Briggs will explain the decision of the court.
Mr. Perry is a retired miner. Like thousands of his colleagues, by the time he retired, he suffered from a condition known as vibration white finger, a vascular condition which typically causes loss of grip in the hands and loss of manual dexterity. This was caused by excessive use of vibratory tools at work. Following a test case which established that the National Coal Board, later British Coal, had been negligent in failing to protect miners from VWF, a scheme was set up which enabled miners with VWF to claim compensation. The compensation took two forms. The first was a lump sum as general compensation for the miner having developed VWF. The second, called a services award, was a tariff-based amount payable if the miner could show that his VWF had caused him to need assistance in carrying out specified types of routine domestic tasks, like gardening, DIY, and car maintenance, which he had previously been able to carry out unaided. Mr. Perry retained Raleys, a firm of solicitors, to seek compensation for him under the scheme. They obtained an offer to pay him £11,600 as general compensation, which he accepted in November 1999. But they failed to advise him that the severity of his VWF was such that he might also be eligible for a services award. Mr. Perry only found out about that possibility from other retired miners long after the time for seeking a services award had expired. In 2009, he began his present claim against Raleys, saying that their failure to give him that advice was negligent and that it had caused him to lose the chance of obtaining a services award. And he estimated that the value of that lost chance was a little over £17,000 plus interest. Raleys eventually admitted that they had failed to give Mr. Perry proper advice, but denied that this failure had caused him any loss. Judge Safman, trying the negligence claim in Leeds, found in favour of Raleys. He said that Mr. Perry had failed to persuade him that, if he had been properly advised, he would have been able to bring an honest claim for a services award. This was because, in truth, Mr. Perry's VWF, although serious, had not deprived him of the ability to carry out the relevant domestic tasks unaided, and Mr. Perry knew that. This was a finding which the judge reached after hearing evidence from Mr. Perry, from members of his family, and considering expert evidence about his VWF. In short, he did not find Mr. Perry a convincing witness, in the light of medical records and other evidence which contradicted his story about his need for assistance. But the judge said that if Mr. Raley had been able to bring an honest claim for a services award, he would have valued that claim under the scheme at £14,500 odd. The Court of Appeal held that the judge had gone seriously wrong in a number of respects. The first and most important was that he should not have conducted a trial within a trial of the question whether Mr. Perry would have made an honest claim for a services award. The judge should just have valued the claim on the basis of a lost chance. This was because the question whether Mr. Perry's VWF caused him to need assistance in carrying out the relevant tasks was a question that would have arisen if, on proper advice, he had claimed a services award. Trying a main issue in the underlying claim as part of the negligence claim was, in the view of the Court of Appeal, contrary to a number of cases about valuing the loss of a chance. The Court of Appeal valued that lost chance as the same amount as the judge would have done, had he not, in the court's view, gone wrong by conducting a mini-trial. Raleys appealed to the Supreme Court. This raises a question of general importance wherever the court has to value the loss to a person of a chance to obtain something as the result of negligence by those providing legal or other advice and assistance. In asking what would have happened if proper advice had been given, the court is not looking at facts which actually occurred. Rather, it is looking at a hypothetical chain of events which might have occurred, something which lawyers often call the counterfactual. The unanimous decision of this court is that the judge was right to require Mr. Perry to prove that, if properly advised, he would, on the balance of probabilities, i.e., more likely than not, have made an honest claim for a services award, and right therefore to examine in full detail the question whether he really was suffering from an inability to carry out the relevant tasks unaided in 1999. This is because the law on this question has been settled ever since the decision of the Court of Appeal in Allied Maples and Simmons in 1995. The claimant must prove, on the balance of probabilities, that, had he received proper advice, he would have taken the steps he needed to take to pursue the relevant claim. But if he can prove that, then the question whether the claim would have succeeded, or whether the defendant to that claim would have paid something in settlement, only has to be valued on a loss of a chance basis. Applied to this case, as the judge said, this meant that Mr. Perry needed to prove that he probably would have pursued an honest claim for a services award if properly advised that he might be eligible. Since the judge found that Mr. Perry knew that his VWF did not cause him to need assistance in carrying out the relevant tasks, he could not, and therefore would not, have pursued an honest claim. The Court of Appeal also found that the judge had gone wrong in a number of other respects, mainly in his analysis of the weight of the evidence. But this court is also of the unanimous view that the very stringent conditions which must be satisfied if an appellate court is to interfere with fact-finding by a trial judge were not met in this case. Accordingly, Raleys' appeal is allowed and the trial judge's order is restored.
Thank you very much indeed. The court will now adjourn.